Okay, what I'm trying to do is break the code of silence in the legal or criminal justice context. It also has here about the police, the police code of silence. Remember what they did to Frank Serpico for living up to the oath? Okay, well, okay, well, the code of silence for legal or criminal justice case. In the legal or criminal justice context, the code of silence acts as a severe institutional barrier that actively obstructs the administration of justice rather than a social agreement. It functions as illegal mechanism of complicity, cover-ups, and systematic corruption that shields individuals from accountability. The phenomenon operates on two different fronts, which the justice system inside law enforcement, the blue wall, and inside local communities. Stop snitching. The eternal code, the blue wall of silence, that occurs when law enforcement officers collectively agree not to report errors, misconduct, or crimes of their peers within a legal case. This code actively compromises the integrity of evidence and testimony. Common manifestations in court cases. Testimony perjury. Testifying officers may fabricate or alter narratives under the oath to protect a colleague from excessive force or illegal search charges. Falsifying official reports, writing police reports that omit a peer's misconduct, synchronized stories, or falsely frame a victim to justify an arrest. Omission of evidence, purposely failing to log body camera footage, dash cam videos, or bystander statements to incriminate a fellow officer. Direct consequences of legal outcomes, wrongful convictions, fabricated police testimony, unchecked misconduct, frequently to imprisonment of innocent citizens. Civil rights litigation, immunity in federal civil rights cases such as 42 U.S.C. 1983 lawsuit. If an entire group of responding officers stay silent about who actually struck a victim, the plaintiff often struggles to prove direct causation against a specific individual, enabling everyone to evade a liability. But if it was in the private sector, everybody would get arrested for his accomplices. All right, I don't know why the rule of law isn't equal on that, but mass dismissals when a whistleblower or investigation unit finally cracks the code of silence. The state is often forced to throw out hundreds of past convictions tied to those corrupt officers due to the total loss of confidence in their integrity. The external code stops snitching and witness information. Conversely, a code of silence can form within a community, dictating that civilians must never cooperate with prosecutors or police investigators. Why the community code forms: fear of retaliation, witnesses of violence, crimes, fear physical harm or death, or for perpetrators if they testify. Erosion of truth. Severe historic police misconduct can cause an entire neighborhood to refuse to assist the state, preferring to resolve the issues internally rather than engage with a system that they view as hostile. Direct consequences or legal outcomes. Unsolved crimes. Prosecutors are routinely forced to stop murder or assault crimes because witnesses refuse to testify or suddenly change their stories or on the witness stand. Unviable trials without credible civilian testimony to build a timeline or identify suspect cases stall, leaving dangerous offenders on the street, denying justice to victims. Okay, so I was trying to break the code of silence in court. alleging conspiracy between lawyers and judges to deny a fair trial, objective, verifiable evidence such as ex parte communications, bribes, or fixed outcomes. Merely disagreeing with the judge's ruling is not evidence of conspiracy, and claims judicial bias cannot be litigated by labeling them a conspiracy. Okay. Direct appeal. So, lawyers and judges conspire to deny a fair trial by violating the rules of professional conduct and the code of judicial conduct. Okay, so that makes what? Okay, so that's what you have. A conspiracy against rights under the color of law occurs when government officials or individuals acting in concert with them use their official authority to willfully violate constitutional rights or federal laws of citizens. This is a severe federal offense with devastating legal consequences. Conspiracy against rights. This law makes it illegal for two or more people to conspire to injure, oppress, threaten, or intimidate any other person. Free exercise or enjoyment of their constitutional rights. It covers both public officials and private conspirators who work alongside them. Deprivation of rights. That's when your lawyer doesn't even discuss with you the rules of professional conduct, yet alone abide by them. Statute makes it clear for anyone acting under the color of law, a parent of actual government authority, or willfully deprive a person of their constitutional rights regardless of racial bias. What constitutes color of law? The act under the color of law refers to a wield power given by a government entity or to falsify, pretend to wield such authority. This concept is not limited to police officers. It applies to law enforcement agents, mayors, judges, prosecutors, prison guards, public officials overstepping official duties while utilizing one's office or badge still counts as an action under the color of law. So your lawyer not abiding by enforcing the rules of professional conduct, the code of judicial conduct, judges not enforcing the code of, or living by the code of judicial conduct, enforcing the rules of professional conduct, that's deprivation of rights, y'all. Okay. They don't mention it here. Let's see. Oh. Not automatically. Violating American Bar Association rules of professional conduct, primary and ethical breach leading to professional discipline, like suspension or disbarment. It only becomes civil rights violation if contact meets specific criteria. A violation may be level civil rights violations, often brought under federal authorities. The attorney may result being acting under the color of law, acting as a public defender, prosecutor, or conspiring with a state judge, willfully engage in state action that explicitly deprives an individual of federally protected constitutional or statutory rights. A purely private attorney simply violating a procedure or ethical duty generally does not qualify, though it may account to legal malpractice or misconduct. Department of Justice enforces deprivation of rights under the color of law for severe abuses of power. Otherwise, ethically, grievances are handled by state-specific attorney disciplinary boards. But remember that, like I said, No, that's not it. Okay, went for that. Oh, I wanted penalties. Okay, penalties for a conspiracy against rights under the color of law range from heavy fines and up to 10 years in prison to life imprisonment or the death penalty, depending on the severity of the offense and if death or serious bodily harm results. They got attempted murder. They tried to murder me. Nearly died, should have died, for demanding my constitutional rights. Okay, people, I'm gonna let you go. All right, I've been doing this all day, but don't mind that. When you do what you love, it's not work. Have a good day. May your Creator always be with you. May He rain many blessings. I wish you a long life and good health. May what I talk to you about serve you well. Nothing but love and happiness, y'all.